So in business law, some part of it, we'll be doing some part of business law, but we might not be able, but we may not be able to cover all aspects of business law. So I'm trying to project my slides. I'm going to pull up the outline that we are about to discuss. But basically, we'll be looking at the court system in Ghana, and then we'll be looking at contracts. Now, contracts is quite extensive, so it might cover a lot of areas. So we'll be looking at the court system, and then we'll be looking at contracts. So contract, when you break it down, we'll start with the theoretical foundations, and we might move to the elements. Then we'll move to decision factors. We'll move to discharge of the contract, and yes. So we'll be looking at all of those parts of contracts. Now, like I said, the law covers a lot of areas. There are a lot of things that we do, we don't even know that there are laws that cover all of these things. So even before we are born to the time that we die, before we are born to the time that we die, everything we do has a law that governs it. If you want to get married, there is a law that governs marriage. Even if you don't want to get married and you want to have relations, there is a law that governs all of these relations, either sexual, all of these things, to make sure that people do not take advantage of other people. So you might even hear about this. I think that the Lumbus case where they were talking about legal wife and then the other ones. Whilst also, I don't know if you heard of the Access Bank manager who promised the national service personnel that he was going to divorce. I think he was going to divorce his wife and marry him, and then he promised her other things. And then clearly he did not follow those things, and because he did not follow those things, the lady sued him. So I just want you to have an idea that every single thing that we do is covered by law. Even before we are born, before we are born, there is a law that prohibits all of the exceptions. I just want you to understand that there are laws that cover all of these things. And after we die, whether you leave a will or you not leave a will, after you die, there are also laws that govern everything. So the previous example that I mentioned concerning the that Limbas issue, you get to know that definitely that Lumba is dead, but his estate is still, or people are still fighting over his estate. And then after they were fighting, everything that you saw, you realize that it was settled at the court. So I just want you to understand that every single thing that we do, they are governed by laws. All right. So please give me a moment and let me project the slides. Saving the slides, I think it's just going to the slides. So there is just the introductory aspects, and then after we will see how far we can move. All right. Please, can you see my presentation? Can anyone see my presentation?
Yes, sir.
Sir.
All right.
So we can see
Thank you
it
very
now.
much. All right. So we'll be going through the definition and the nature of business law, and we'll be looking at the concept of law in general. So we'll be looking at the definition of business law itself, and we'll be looking at law in general, and then we'll be looking at the evolution of common law and then judicial precedent. And then after, we'll be looking at the Ghana legal system and the court structure. Now, this is very important because when you have a case, there are some courts that cannot adjudicate some cases. When I say adjudicate, I mean there are some courts that cannot hear and decide on a case. Please, one thing, anytime that you are not talking, kindly mute yourself. I think Sifa can you mute yourself for me. When I ask a question, you can just omit an answer. Or if you have a question, you can give the answer. But once I'm speaking, kindly mute yourself. All right, thank you. So, looking at the Ghana legal system, and we're looking at the court system in Ghana. As I was saying, there are some issues that you cannot say with certain types of courts. When you say the even you mean a higher court like the higher court or the supreme court can issue a warrant, so can issue an order to squash that particular decision. So there are some courts that you can go to and there are some courts that you cannot go to. As businessmen, definitely you would have disputes with people. So one way of resolving this dispute is by going to court. However, it has been advised that we shouldn't be in a hurry to go to court because court has a disadvantage. Because if you go to court and the person loses, the person might not want to do business with you again. So one means of resolving disputes is by taking, and that's known as litigation. Another means of resolving dispute is what we call the alternative dispute resolution. That is why right after the legal system and court structure, we have the alternative dispute resolution. So litigation is settling disputes in courts, and then the alternative dispute resolution is settling disputes outside of courts. We go to the types of ADR, some what is the mechanisms of ADR that you can use to resolve issues. However, at this moment, have it in your mind that at any point in time, if you have a dispute with somebody, you can decide to go to court, or you can resolve, or you can resolve it outside of court. If you choose to go to court, then it is called litigation. If you choose to use other means, then it is called alternative dispute resolution, which is shortened as ADR. Both litigations and ADR have their advantages and disadvantages. Somebody is unmuted. Please, anytime that you're unmuted, make sure that you have a concern or you have a question before you unmute yourself. All right, thank you. So you can either go to court and settle your disputes, and then or you can settle your dispute outside of court. Going to court has its own merits and demerits, and also using ADR has its merits and demerits. However, as businessmen and women, we are encouraged to use ADR. As businessmen and women, we are encouraged to use ADR because it has more advantages. It has more advantage. However, because of the drawbacks, if you are not interested in ADR, you can go to court. However, anytime that you go to court, it might not result in your favor. Whilst if you are using ADR, you can come to a compromise. And when you come to a compromise, it can result in a win-win. However, when you go to court, it is most likely going to be a win-lose. One person is going to win and one person is going to lose. All right. So next, we'll be looking at arbitration proceedings in Ghana. Now, one of the mechanisms of ADR is the use of arbitration. The use of arbitration. So when we get there, we'll discuss all of them, and then the predominant one is the arbitration process. The arbitration is what we call a quasi. It's also quasi, something that looks like something. So quasi, Quasi, quasi. It looks like something, but it is not the actual thing. So with an arbitration process, it is similar or it looks like a court system, or it looks like you've gone to court, but you've not gone to court. Sorry, don't mention your name well. Amiyao, your hand is raised. Amiyao. I don't know if I'm even gotten it right.
Yeah, sir. I don't know whether it's just only my side. It's breaking. Your voice is breaking. I don't know whether it's only my side.
The same as here. The same as here.
Yeah.
My voice is breaking.
Yes, please.
All right. I'm using a Bluetooth device. Let me put it.
Let me see if it's just the network or it's my Bluetooth device. Is it okay now?
Yeah,
Hello,
say
is it
it's
okay?
okay.
It's good.
So okay, so it was my
Yes,
Bluetooth
please.
device. All right. So next we're going to
Oh, it seems
contracts. All right. So next we'll be going to contracts. And with contract, we'll be looking at the theoretical foundations, formation, and then classification of contracts. Theoretical foundations are just the theories that underpin the formation and enforcement of contracts. And then we'll be looking at the formation. Whilst we are looking at the formation, we're looking at the elements of contracts. Elements. And anytime that you hear elements of a contract, know that there are the things that come together to form a contract. The things that come together to form a contract. So anytime that one element is absent, know that what you have is a defective contract. So the element that we will discuss in our next meetings, anytime that you have a contract and you check all of the elements and you realize that one of the elements is missing, then we are saying that you have a defective contract. So the elements include the offer and acceptance, we have consideration, we have capacity, we have intentions to create legal relations, we even have legality of the subject matter. Legality of the subject matter. That one is also part of the elements. And then we're looking at the classifications of contracts. Classifications of contract. We have written versus oral contract. We have the simple contract versus specialty contract. We have the unilateral contract versus the bilateral contract. When we get there, we will go through all of these classifications. Now, next, we have terms of a contract. Terms of a contract. And the terms of a contract include the conditions, the warranty, and then the inanimate terms. Each of them has its own meaning. If you breach each of these terms, I know that we are not there yet, but when you hear breach, that means that if someone wrongfully terminates a contract or someone does something in a contract that causes an injury to the other person, and it is in relation to any of these terms, then we are saying that each of them has the remedy that it can go for. So when someone breaches a condition, the remedy is not the same as warranty. I know I'm using words that you might not have heard of. When I say remedy, I mean the basic definition I can give you is anytime someone wrongs you, you can go to court to seek for something, for either appeasement or to seek for something in order to make sure that you've been satisfied. This is the layman definition that I can give you. So when you breach a condition, it is different from when you breach a warranty, and then we also discuss inanimate terms. Now, we'll also be looking at exemption clauses. Exemption clauses. Now, these are clauses that usually people use to limit or remove their liabilities. So anytime that you are signing a contract, you see that sometimes there are some words that are written, they are bolded and then they are italicized to make sure that you see them and then you read them. So these things are usually used to either limit or eliminate their liabilities. I know we are not there yet, but let me give you an example. Anytime I go to a hotel or a guest house, when I go to the car park, you see that at the car park they've pasted something there and they've written, if anything happens to your vehicle here, then the hotel or the hotel management. So they are telling you that even if you know that I don't know if it's my network. Is the presentation showing?
No, sir.
Yes.
No, please.
I just arrived in Cape Coast and the network here is really bad. I don't know why. All right. I'm using the same network on my phone compared to my laptop. I don't know why the presentation is off. But can you hear me clearly? Hello,
Sir,
can you hear
please,
me
it's
clearly?
breaking.
It breaks. It breaks.
It's breaking.
Yeah. Because even MTN is giving a problem. If I switch to Tigo, I'm not sure I'm going to have the network on Tigo. Because even AT is not available here. The only other alternative I have is Telecel. And the Telecel, I'm not sure it is better than the MTN. All right, please, is it okay now? Hello, please give me a feedback. Is it okay now?
No, please.
Yeah, it's
No, please.
Hello,
Sir, please, it's not okay.
Not yet. So now.
hello, please, can you hear me?
Sir,
Yes,
please,
sir.
we can hear, but then it breaks
Hello,
at a time. Sir,
hello.
Hi.
Yeah, hello. Hello,
hello,
I'm back.
sir.
Please, can you hear me? All right. Sorry about that. My network went off. I've switched and let me see whether this will be better. All right. Please, anytime that you cannot hear me properly, kindly prompt me so that I will adjust my network. All right. So, like I was saying, we were on exemption clauses where I said this is where they use these clauses or these terms to limit their. Please, anyone who's unmuted, can you mute yourself? Thank you. All right. So they use these exemption clauses to limit or to avoid any further liability in a contract. Now, then we'll be moving to vitiation factors. vitiation factors. Now, vitiation factors are factors that affect the validity of a contract. They affect the validity of a contract. So anytime that there is a vitiation factor in a contract between two people, then there is something wrong with that contract. There is something wrong with that contract. Now, let me give you some examples so that even though we are not there yet, you'll understand what a vitiation factor can be. So, a vitiation factor can be misrepresentation. Misrepresentation. And when we say misrepresentation, the non-legal definition will be that when someone lies to you to get you to enter into a contract. When someone lies to you to get you to enter into a contract. Now, that is just an aspect of vitiation factor. I just want to use it so that you get an understanding of what a vitiation factor is. Now, if someone lies to you to get you to enter into a contract, and then you find out, that is called misrepresentation. Now, with this misrepresentation, you have some remedies under the law. So now, the basic understanding of what I want you to get is that if you lie to someone, or if someone lies to you to get you to enter into a contract, then that contract becomes defective. That contract becomes defective. So whether it is you doing the lying or someone else lying to you, it makes the contract defective. So anytime that any of these vitiation factors are present, it makes the contract defective. So we'll be looking at misrepresentation, where I said when someone lies to you to get you to enter into a contract. But the legal definition is where someone gives you a false representation, when someone gives you facts that are not true to get you to enter into a contract. That is the legal definition of it. We'll also be looking at mistakes. And we'll be looking at undue influence, we'll be looking at duress, and we'll be looking at public policy, illegality, and then unconscionability. So all of these are types of undue influence, and anytime that they are present, they make the contract invalid. They affect the contract somehow. Now, all of these things, when we get there, we are going to explain. So it can make a contract void, voidable, or unenforceable. Now, next, we'll be looking at discharge of contracts. Discharge of contracts. Now, with discharge of contracts, anytime that people can put a contract together, the contract can come to an end. So anytime a contract can come together, a contract can also end. So we'll be looking at the various ways by which a contract can come to an end. Now, all of these ways, we have lawful means and unlawful means of ending a contract. There are some means that when you use, they are legal, and there are some means that when you use, they are not lawful. Now, if you use an unlawful way to end the contract, then the person will be entitled to remedies. The person will be entitled to remedies. So next, we'll be looking at remedies and the types of remedies that we have. The types of remedies that if someone breaches a contract or someone injures you in a contract, the types of remedy that you can pray to the court for. The types of remedy that you can pray to the court for. Last but not least, we'll be looking at torts. We'll be looking at torts of negligence and product liability. Now, we have a lot of types of torts. We have a lot of examples of torts, but we will be looking specifically at negligence and product liability. These are the two that we'll be looking at, negligence and product liability. So an example of torts can be assault and battery. An example of torts can be trespassing. All of those ones are all examples of torts. Examples of torts. But we will be zeroing down to negligence and product liability. I wouldn't talk much on it. When we get there, we'll get to know what negligence is and how it plays a part in product liability. With product liability, we have other forms of product liability as well. So we'll be looking at all of these things. And then also looking at intellectual capital. Intellectual capital. What is intellectual capital? When you bring up something new. When you bring out something new, what can you do to protect your innovation? What can you do to protect your invention? We're looking at all of these. If you are also employed if you are employed by someone and then if you work under the person and you come up with a new idea, how much of that thing belongs to you and how much of that thing belongs to the person. So we'll be looking at all of these things, and you can also have a contract in place where if you bring something new, a contract stipulates how it is shared. But if the contract doesn't stipulate how the intellectual property is shared, then you might have to resort to splitting it according to the provisions of the law. So these are what we'll just be looking at this semester. Next semester, we'll be looking at other forms of it. So let's start with the concept and then the historical evolution of the Ghana legal system, the court structure, and then alternative dispute resolution. That is what we'll be looking at. So at the end, at least you should know the nature and scope of business law. You should know the concepts, classifications, and importance of law. You should be able to describe the components of the Ghana legal system. You should also be able to explain the structure of the court system. And also, you should also know to understand these mechanisms and know which one is appropriate at all time. All right, so we're looking at the definition of business law. Now, this is business law, only business law. We've not expanded the definition of law. We are focusing on business law, and then after we are going to expand it to business law. So, business law is the body of law which governs business and commerce. So, any type of law that governs business and commerce, we are saying that it is a business law. So it governs the dealings between people and commercial matters. It is a branch of civil law. We'll be discussing civil law soon, the difference between civil law and common law. We'll be discussing all of those ones soon. But here, understand that business law is a branch of civil law, and it deals with issues of both private and public law. Business law is sometimes known as mercantile law or commercial law. So sometimes you might see a book and the book will write commercial law behind it. When you open, you would see all of these elements in them. So the nature and scope of business law provides a clear-cut and enforceable rules and regulations to avoid issues and conflicts in the world of commerce. The scope of business law includes laws relating to contracts, partnership, negotiable instruments, sale of goods, companies, employment, agency, and insurance. So these are examples of business law. Sylvester. Hello, Sylvester. Sylvester.
Hello, sir. Yeah. So the slide was not
Hello,
showing that.
Sylvester. No.
Your slides were not showing.
WhatsApp audio.
The slide is off.
Mine is on, sir.
All right. So even though the slide is off, are you hearing me correctly? Is my network okay?
Yes, sir.
Network is low. I think the slide is. I think that this one is back on. Let me make it a little bit bigger so that you can see. All right. So examples of business law. We have agency law. You'll be treating agency law next semester. We have carriage by land and sea. Unfortunately, you will not be treating that. We have terms of guarantee. You have partnership law. Partnership law. Next year, level 300, when you are doing company and partnership law, you'll be looking at partnership law. Partnership is basically a business, a type of business where people range from 2 to 20. So it's a type of business where people range from 2 to 20. And then they have their own laws that govern them. The laws that govern partnership is different from the law that governs companies, and also different from sole proprietorship and in that regard. I know as business students, you've done a little bit of all of these things in business management when you were in SHS, but as some people always say, is sometimes it's been quite a while. So we are taking them through all of these ones again. Now you also be doing hire purchase. you will be doing hire purchase law. With hire purchase, it is where someone will buy something or someone has the option. So someone will rent something from you, and then at the end, the person has the option to either buy it or not buy it. All of these, you'll be treating them next year. This will be treated next semester, but this will be treated next semester. And then the accounting students, I think both BEd and BCom accounting, you would be doing corporate financial reporting, also in level 300. You will be doing the accounting part of the higher purchase. You'll be solving accounting part of the higher purchase next year as level 300. Also, taught law in land law of trusts. Trust, the person comes of age, and the person will come for it. So we also look at the law of trust. We look at sale of goods. Sale of goods. The law that governs the buying and selling of goods. You also be treating that next semester. And then we're looking at marine and merchant shipping. Unfortunately, you'll not be treating this. We're looking at insurance and bills of exchange. Insurance, you'll be treating it. Bill of exchange, you also be treating it. Company law itself, like I said, level 300 will be treating it. Criminal law, we are not explicitly treat criminal law, but you may see some of the elements in them. Then you have the conditional sale agreement, bill of lading, and then negotiable instruments. Negotiable instruments is treated under banking law next year, so all will be treated next year. So these are the type of laws that you might encounter as a business person. So as a business person, you should at least have an idea of what most of these things mean. What most of these things mean. So at the end of level 300, they've covered most of these laws. Most of these laws. So as a business student, when you're asked anything in regards to business law, you should be able to answer. All right. So splitting them, we have the Companies Law, which is governed by the Companies Act 2019, Act 992. We had a former Act 1963, Act 172, which was replaced by this Act 2019. So these this is the new Companies Act in 2019. And then we have insurance law, which was insurance law, which is governed by Act 729 of 2016. Then we have employment law, which is governed by the Labor Act 2003. Now, this employment law, as accounting and finance or beer accounting, you will not explicitly be treating employment law, but when you treat contract, an employment law has an element of contract in it, so you may be able to look at it, but you will not explicitly be treating labor law. I think those who be treating employment or labor law are the people in HR. So if you have any HR students here, have it in mind that you will be treating the labor law or the Labor Act. So it is governed by the Labor Act 2003, Act 651. You'll be treating contract law, which is governed by Act 25 of 1960. Now, this contract law that we'll be treating, definitely we'll be treating it this semester. That is the next topic after this, like the next unit after this. And we'll be treating agency law, which deals with agency principle and then a third party relationship. This also will be treated next semester. Then we'll be treating sale of goods, which is governed by Act 1962, Act 137. And hire purchase is also governed by 1974 Act NRDC Decree of 292. Now, you see that you are seeing acts attached to this. Now, even before you move to the types of law, know that there is a type of law that's the common law. The common law that we inherited from the British. The common law that we inherited from the British. So you might see, anytime that you see a principle that has a case with it. Hello, someone is unmuted. Does the person have a concern? Someone is unmuted. Does the person have a concern? All right. Let me use this opportunity to Marina. All right. let me use this opportunity to ask whether the network is okay and I can still continue.
Okay.
Is the network okay? Can I continue?
Yes, sir. Yes, sir.
Yes.
The network is okay.
All right.
So
All right. Thank you.
sometimes it breaks.
Oh,
Sometimes when you're talking, then it's breaking. So we can't hear what you are saying very clearly.
Yeah, I'm listening.
Please.
Is everyone facing this challenge?
Yes, sir.
Is everyone facing this challenge? All right, but I hope it's okay
Yes,
now.
sir.
Like as I'm speaking now, it's okay.
yeah, it's okay now.
Hello, I hope it's okay now.
Yes, sir. It's okay.
Yes, please, it's okay now.
All right, so all right. So as I was saying, even though there are acts that govern, all right, thank you. So even though there are acts that govern this, sometimes when you are treating them, you would see some cases, and those cases may or may not come from Ghana. Now, the cases that may not come from Ghana are the cases that it is generally known as the common law, the one that we inherited from the British. Now, the British at first they didn't have a codified law that they were using. So anytime that there's an issue, they will judge it, and then based on the judgment that they give, that is what they will judge subsequent cases with. So we've inherited a lot from the common law system. So there are some principles that you see that it is just the common law. You see maybe A versus B, C versus D, all of those cases, most of them we inherited from the British. Now, if you see a Ghanaian law, that is a law that, or if you see a Ghanaian case, that is a subsequent case that has been decided in Ghana, and that also forms part of the laws that we have in Ghana. That is a different issue. But if I'm talking about common law from the British, these are cases. So sometimes the thing that you need to know about this common law and this act is that
It's breaking. So it's still breaking.
it's still breaking it. All right, hold on, I'm coming. Give me a minute. All right, hello, please. Is it better now? Hello, is it better now?
Yes, sir.
Yes,
Yes,
sir.
please.
Okay, so anytime that it dips or probably can't hear, can you prompt me so that I'll check on it? All right, so like I was saying, when you see these acts, they are complemented by the common law that we inherited from the British. Now, these common laws, they provided principles that we inherited. Now, the important thing that you need to know about this is that if those principles in those cases does not contradict the law that we have in Ghana, then we can go with that principle. But anytime that those principles contradict with a provision in our act, then we go with our act. I take it again. Anytime that those principles do not contradict with any provision in the Ghanaian law, being it any type of enactment that you see, if they do not contradict, then we can go with those principles. But the moment they contradict with any provision in the Ghanaian law, then that provision supersedes that principle from the common law that I'm talking about. So that's the important thing that you must know. So you can see that with the agency law, there is no act attached to it. That means that most of the principles that we have with agency, it is still the common law system that we are using. That's the common law that we inherited from the British. So you see that most principles under agency laws, they are mostly cases that we derive from them. All right. So we'll be moving on to the concepts and classifications. Also, we'll be looking at the importance of law. So what is law? So anytime we say law, what is law? Now, law, usually when it comes to law, a lot of scholars have defined law based on their understanding. So we can have a unified definition of law. We can have a unified definition of law. But you can also see law from various schools of thoughts. You can see law. I think the presentation has stopped. Let me check on it. So you can have laws from various definitions. You can have laws from various definitions. But usually they are talking about the same thing. So examples that most people decide to use is when blind people are touching elephants. So when blind people are touching an elephant and you ask them to define or to explain what an elephant is, they would explain it based on what they touched. So if someone touched the side, they might think an elephant is like a wall. When someone touched the trunk, so they may all have their own definitions. But they are all describing an elephant. That is all I want you to know. The presentation is still not coming. All right, so even though the presentation is not coming, is the voice okay?
Yes, sir.
All right.
It's
So
okay.
I'll be working on the. All right. So I'll be working on the presentation as I move on. So we have most prominent views on the concept of law, where we have the positivist versus the naturalist. We have the positivist and then the naturalist. Now, the distinct or the definition of these two schools of thought is very important. Even though they all touch on an aspect of law, they are all not entirely right because laws are such that they intersect. So a positivist is going to tell you that a law is anything that comes from someone who has authority. So anything that someone says, someone who has authority says, that is a law. And that is true. So with the positivists, they don't care whether the person has the power legitimately or illegitimately. They don't care whether the law is good or it's not good. They don't care whether the law is moral or it's not moral. All they care about is if it is coming from someone of authority, then it's a law that must be respected. It's a law that must be respected. But with the naturalist point of view, they see law as something that is moral. So they see that law comes from nature, and nature has prescribed certain rules for us. That is why we are not supposed to do a lot of things. So they see laws to be right and wrong. So they don't see laws coming from someone with authority. They see laws as, okay, so if something is good, then we are saying that then we are not, if something is good, then we are going to do it. And if something is bad, then we are not going to do it. So they don't derive the definition of law from whether it is coming from an authority or not. So positivists define it by it coming from authority, and then naturalists define it with nature, saying that these laws should either be good or bad. And then if they are good, then it means that the law will encourage it, and if it is bad, the law is going to discourage it. So that is the basic definition of the positivist versus the naturalist. So I'm reading. So the positivist advocates that only legitimate sources of law are those written rules, regulations, and principles that has been expertly enacted, adopted, or recognized by a governmental agency. So according to them, law is seen as something that is devoid from moral consideration. So law is devoid from moral consideration. If someone of authority says it, then it means that that is what the law is. That is all they care about. So proponents of this theory include John Austin, Professor H. Eliot, and Prof. Hans. So John Austin defines law as the command of a sovereign backed by a threat of a sanction. So according to John Austin, law is the command of a sovereign. A sovereign is someone of authority, backed by a threat of a sanction. And that is an aspect of definition of law, because a law is something that it is coming from an authority. And if you breach it, there will be consequences. So according to the positivists, that is how they define law. And according to him, the law is the command of a sovereign and who has the right to do what he likes and is habitually obeyed. Disobedience of such a command is met with sanctions. So these positivists only look at law from the point that it should be respected. If it is coming from the authority, then it should be respected. Now, the naturalists, according to the naturalists, they said all laws must be informed by or must be comported with universal principles of morality, religion, and justice, such that a law that is not fair should not be recognized as a law. So according to the naturalist, even if it is coming from an authority, if it is not fair, then we are saying that it should not be recognized as a law. So proponents of these laws include Plato, St. Thomas Aquinas. So St. Thomas Aquinas defined law as a rational ordering of things, which concern the common good that is promulgated by whoever is in charge with the care of the community. So natural law believes that there are necessary connections between morality and law, while positivists do not. So naturalists think that law should be moral. Naturalist. Positivist, so far as it comes from an authority, it is a law. So even with these ones, how Ghana enacts our laws, you can see that sometimes our morals inform some of these laws. For example, the anti-LGBTQ bill that is now with the Supreme Court, I don't even know where it is now. I think they postponed it indefinitely. So you could see that there is an aspect of morality driving this law. Even though it is coming from Parliament, there's also an aspect of morality driving this law. And according to them, their argument is that it is not compatible with the Ghanaian way of life. So they are injecting their morality into these kind of laws. Which type of morality? They explain that there are three main types of religions in Ghana: Christians, Islam, and then we have the traditionalists. And they argue that they all oppose these same-sex kind of relationships. So we are saying that a law defined by the two schools of thought. And then when you look at all laws, you can see that they cut across. You can see that some laws are just recognized because they are coming from authority, and some laws also, you can see that there are some moral backends. There are some religious and moral backends when it comes to these laws. So these are just the definitions from the two schools of thought. That is the positivist versus the naturalist. I still can't get a presentation. All right, let's move on. So we have the systems of law. Systems of law. So the systems of law, we have the common law system and then the civil law system. Now, if we are contrasting the types of laws that we have, every law has its definition, or every classification of law has its definition. But when we are contrasting, we contrast the main aspects where it contradicts. So you can see common law versus law of equity. The distinction when it comes to common law versus equity is different from the distinction we are making between a common law system and a civil law system. So when we are classifying it, sometimes we classify it based on it as a system. Sometimes we classify it based on whether it was written or it wasn't written. We classify it as to whether it governs the type of relationship that it governs. So all of these are classifications of law. But first, let's do the systems of law before we break it down to the classifications of law. So there are two basic classifications of law. We have the common law system and the civil law. Now, most nations follow one or two of these legal traditions. Ghana here, since we were colonized by the British are the people who were using the common law. So we inherited a lot of the common laws. Now, the two main difference between the system is that the common law was based on judicial opinions, whereas the civil law system was codified. So when it comes to the common law, it was used by the British. The common law was used by the British, and the British didn't have their laws written down. So when they come to your community and they come and adjudicate a case for you, they adjudicate based on principles. And then after they adjudicate, those principles become laws. And then if there is a similar case, that appears elsewhere, we are going to use that same principles to judge. That is what is known as a precedence. So they have a judicial precedence. So that's how their laws came together. So that's why it was common, because they applied a common law system for everybody. So if the case is similar, then the principles will be the same. So that is what the common law system was about. So the common law didn't have people sitting down to write the laws. It had the judges or the people who were sent out, the kingsmen who were sent out to go and adjudicate. They were the people coming out with the principles, and then those became laws. So that is what is known as the common law system. And then with the civil law system, those ones followed a codified principle. That means that the laws were written and were passed down to the judges. So the judges didn't have any room to do anything. All they needed to do was that they were supposed to follow the codified laws. So they will read the laws and then they will apply it to your case. They will read the law and then they will apply it to your case. So civil law system was written and codified, while the common law system was not written and was not codified. So the original source of common law can be traced to the English. So the English are the people who proposed or who came up with the common law. And then the civil law system were used by other Europeans. So most of the Europeans were practicing the civil law system, whilst the English, that is the British, they were using the common law system. All right, so I think the presentation is back. All right. All right, let's move on. So any moment direct response, I'll just present. I don't know why it's taking a lot of time. But still, is the voice okay?
Yes, please.
Yes, please.
All
Yes,
right.
sir.
Okay.
The voice
The
is
voice
clear
is
now.
okay, but your slide, you can't see the slide.
Yeah, I'm trying to project the slide, but I don't know why. I'm using the same network. I don't know why the slide. Okay, so I think, yeah. Is it showing now?
No.
No, we can't see.
Still.
So please, I want to suggest once is in the same model we are using, let's try to open ours and follow whilst we present.
Yeah,
Because
you can open yours and follow whilst I try and then project, because it is showing that it is presenting. I don't know why it is not responding here. But anyway, let's continue.
yes.
All right. So The original source of the common law can be traced back to the English monarchy, where they issued formal orders which were known as writs when justice needed to be done. Now, because the writs were not sufficient, the court of equity was established. So this one is also a contradiction between the common law and then the law of equity. Now, the common law was a very harsh system. So even though we are doing common law versus civil law, let me chip in the common law versus the laws of equity. Now, the common law was a very harsh system, because if there is a principle and the principle says this, then it doesn't matter whether there were tweets or there were turns, the common law will just apply those precedents just the same way, whether it is fair or it was unfair. So people who were having their cases thrown out of the courts and people who thought that the decisions were unfair were now going to the court of equity. So the king also gave them a chance that if you think that your case has been unfairly adjudicated, you can come to the court of equity and then they will look at the case and then they will give you a fair judgment. So in the English common system, they had the common law and then they had the law of equity. They were using both concurrently. So an example is, at first, let's say your father is going to war or your father is about to die. Now, if you are not someone of age, you cannot own a land. If you are not someone of age, so let's say the British were raising 21 years. So if you are not 21 years, you cannot own a land. So if your father is going to war and your father might not come back, your father can give the land to your uncle. That if you come of age, then your uncle will just give the land back to you. However, if your father is leaving the land for your uncle, he will register the name in your uncle's name. So it is like he has passed the land to your uncle. However, he has just given the land to your uncle for your uncle to hold it, and then after that, he'll give it back to you. Now, if you come of age and you want to collect the land from your uncle, when you go to the common law, an example of a judgment that can be issued is that anyone whose title is on an item, the item belongs to the person. So when you go to the common law system, they don't care whether it was given to him for him to later give it to you. If the principle is anytime that your name is on something, that item belongs to you. It doesn't matter where you take it to. In the common law system, even if the nephew sue the uncle, when they go, the principle is that whose name is on the or whose name is on the title. So far as your uncle is able to prove that his name is on the title, then that is it. The land is not going to revert to the nephew again. So under this system, the nephew can now go to the court of equity. The nephew can now go to the court of equity. And if they go to the court of equity will actually listen and then look at the twists and turns. And the court of equity can overturn the common law rules. So if he goes to the court of equity and the land actually belongs to him, then they can revert the land back to the nephew. So the common law was very rigid, that if a principle is set, they use the principle throughout. However, the courts of equity were looking at other aspects of it, and then they were flexible in nature. And also, as any system, the common law system, the rich people were using it to bully the poorer people. Sometimes before you go to court, you need to pay some dues. The people were not able to afford those things. So the rich people were also using it to bully the poor people. So anytime that you have a case and you think that the common law system was going to be unfair to you, then they can revert to the law or the court of equity. Now, these two courts were just fused as they went along. So they all came to be known as the common law. But when they started, they were different. We had the common law and the laws of equity, but they were fused and the courts were fused, and then they were using the principles concurrently. This is just by the way, this is the difference between the common law system and then the law of equity, but they fused it together now. So anywhere that you see maxims of equity, those maxims of equity came out from the court of equity. Those maxims of equity, they all came out from the court of equity. All right. So moving on. What led us to this was that because rates were not sufficient to cover all situations, the court of equity were ultimately established to hear complaints and devise appropriate remedies based on equitable principles taken from many sources of authority, such as the Roman law and then the natural law. So all these decisions were collected and published, and it became possible for the court to look at presidential opinions and apply them on current cases. So that is the common law. So when they fuse the courts, they combine everything together. And then whether the decision was coming from a common law perspective or an equitable perspective, they put them all together, and that is where they derived their laws from. However, with the civil law system, the laws were written down. And then when the judge picks the law, he reads the law and then he applies it to your case. All right, so moving on, I'm reading. So the civil law in other European countries, you see, I said that the common law system were practiced by the British. That's the English, and then and then the civil law system were practiced by the other Europeans. So the civil law in other European nations, on the other hand, is generally traced back to the code of laws compiled by the Roman Emperor Justinian around 16 CE. Authoritative legal codes with roots in these laws then developed over many centuries in various countries, leading to similar legal systems, each its own set. So the
Sir, please, is your net breaking?
difference between the common law system and the civil law system. Again, wow. Okay. Is it better or still? Hello, please. Is it better or still?
So it's okay now.
All right, thank you. So the basic principle is that the common law system were judge-made rules, and then the civil law system were codified principles that the judges were using those codified principles to actually come up with a decision. So let's go to the classifications of law. Classification. So the classification, we are going to contrast two different types of laws together. We're going to contrast two different types of laws together. I think the presentation has stopped again, but you can still use your book. Since you're using the same model, you can use your book, and then when it comes, you can follow me with it. All right, so we have the substantive versus procedural laws. Substantive versus the procedural laws. Now, substantive laws are the laws that create and control the rights and duties of parties. And then with the procedural law, it tells us the process of enforcing the rights and these duties. So we have a law that tells us the rights and duties of parties, and when they breach them, their punishment and everything. And then the procedural law is the law that we use to look at the procedure. So for example, when you pick the criminal code, we also have the criminal procedural code. So the criminal law is telling us that when you steal, you would have this number of years attached to you. And the procedural law is telling us how you'll be prosecuted, how you'll be sent to court, how everything is going to go. So that's the difference between the substantive and the procedural. Substantive creates and controls the rights and obligations or the duties of the parties. And then the procedural is telling us the process that we are going to use. So that's the difference between the substantive law and the procedural law. Substantive creates the rights and it also controls the rights and duties, while the procedural law is mostly based on the process of enforcing these rights and duties under the said substantive law. Now, next we go to the private law and then the public law. Private law and then the public law. Now, private laws are laws that deal with individuals. So if two individuals have an issue, we have private laws that regulate that. And then the public law is said to have a relationship between the government and everyone else. So private law is between two individuals. Public law is usually between the government. It's usually the public law is between the government and then the individuals. So an example of private law is contract. When you have a contract with someone else and the person breaches the contract, you can sue that person. So when you go to court, a contract is actually what? A private law. Contract is a private law. So you sue that person. But when it comes to the public law, when it comes to these the relationship between the government and then the citizens, it is one that if you breach, you are prosecuted. So the private law deals with relationship between two individuals, and then public law deals with the government and then the individuals in the country. Now, under these umbrellas, then we can bring it down to criminal versus civil law. So criminal law is a species of the public law. Criminal law is a species of the public law, which creates and controls wrongdoings against the whole community. Now, criminal laws are called crimes. Examples include assault, burglary, and then robbery. Now, with this criminal law, which is under the public law, so always have it in mind that criminal law is under the public law. I'm saying it's under the public law because the public law covers most other laws. So the constitution or the constitutional law is also a public law. So if you are giving examples of public law, the constitution is also a part of the public law. If you break the constitution, mind you, you will be in trouble. So the criminal law is a species of the public law. Now, the criminal law looks at the rights and wrong, or it prescribes what is a crime under a jurisdiction. So we are in Ghana, so we are going to use Ghana. So a criminal law prescribes what is a crime in Ghana. And if you breach it, it also has the appropriate, or it has the recommended years of punishment that you must be dealt with. So that is the criminal law. Mind you, if you breach a criminal law, you are persecuted. If you breach a criminal law, you are persecuted. If you breach a criminal law, you are persecuted. However, with the civil law, it is concerned with private rights and remedies. It is concerned with private rights and remedies. So with the civil law, it's a duty that exists between persons, organizations, and then governments, other than those that commit crime. So with the civil law, it can deal with everyone. However, it omits the criminal aspect of it. So let's get the distinction between the private and public law and the criminal versus the civil law. Is it the civil law has been mentioned here, but the definition given to a civil law is different from when you are contrasting a common law system and a civil law system. So like I said, anytime that you are contrasting these two words, look at whether you're looking at the system or the type of law that you are dealing with. So private laws deals with individuals and one another. Private laws, individuals and one another. And then public law deals with the government and the individuals. Public law deals with the government and individuals. And then when we break it down to civil and criminal law is a species of public law, but it is only concerned with crimes. It is only concerned with crimes. That means that if you breach any of these laws, you are persecuted. When you breach a civil law, you are sued. So people can sue you when you breach a civil or a private law. However, when you breach a criminal law, you are persecuted. So if you commit a crime even against an individual, the government will take over and then prosecute that individual on your behalf. Now, mind you, if you commit a wrongful act, it can have both a civil element and a criminal element. So the person can also sue you, but the government only looks at the criminal aspect of it, where you'll be prosecuted. And then when it comes to criminal law, it seeks to punish. It seeks to punish. Criminal law seeks to punish, whilst the civil law system just seeks to grant compensation to the other party. So anytime that you commit a crime, the punishment or the verdict that is given is seeking to punish you. It is seeking to punish you. So when you see the state versus this, the state versus that, then that is the state persecuting someone else. The state persecuting someone else. So civil law, you sue; criminal law, you are persecuted. All right, so next we move on to international laws and domestic laws. These things are simple. With international laws and domestic laws, we look at international law being laws that govern countries, and then domestic laws are the laws that govern us in Ghana here. And then we look at the common law and then statutes. You contradict common law and then statutes. So common law is a judge-made law. Common law is a judge-made law, and the statutes are the ones that are passed by the legislative arm of government. So when you're contradicting a common law and then statutes, you know that common law are judge-made laws, and then statutes are laws that originate from the legislative arm. When I say the legislative arm, I'm talking about the parliament. I'm talking about the parliament. So these are the classifications of laws that we have, and then depending on the context that you are classifying them, you have to know the distinction that we are looking for. You have to know the distinction that we are looking for. All right. So next we move on to the functions of law. Functions of law. So we have the judicial function. The judicial function. Now, the judicial function basically is to interpret the laws. So, whilst interpreting the laws, then they can adjudicate disputes and issue a decision based on how the disagreement should be settled. So, the judicial function is to interpret these laws. So, anytime that there's even a confusion about an act, about an instrument, or about anything, if you want the definition of it, you go to the the court, that is the judicial side, and then they are going to interpret the laws for you. Now, whilst interpreting the laws, they use this to adjudicate disputes and issue a decision as to how the disagreement should be settled. Now, even though they are interpreting the laws, any decision that they come out with is a law. The decision that they come up with, it becomes a law. It is known as precedence, and it is binding on the lower courts. So if the Supreme Court comes up with a decision, the decision that it comes out with, also, even though it's a decision to settle a dispute, that decision also becomes a law, which is known as a precedence, and it is binding on all lower courts, such as, or all courts below it, such as the Court of Appeal, the High Court, and then the lower courts known as the Circuit Court and the District Court. But their primary function is to make sure that they interpret the laws in order to adjudicate disputes, and then they issue a decision on how this disagreement should be settled. And they move on to the legislative function. That is the legislation. Now, the legislation functions are to determine the rules that will govern the process of adjudication, as well as creating the rights and obligation. So the legislative function of law is to make sure that they come out with the laws. They come up with the laws. And mostly, or in Ghana here, the basic legislative function of the law has been given to Parliament. The basic legislative function has been given to Parliament. So the legislative function of the law has been given to the government. And then this legislative function is to make sure that they come up with the rules that govern education, as well as creating the rights and obligations. So Parliament is the one to come up with the rights and then the obligations, and also how everything should move. So this legislative function is carried out by the Parliament. And then we go on to the executive part of it. The executive part of it. Now, the executive part gives the legal system teeth, which provides incentive for peaceful behavior. So they provide incentives. So when we look at the executive function, then we are looking at the enforcement of it. So that's where we can look at the law enforcement, where they execute the law. So the law enforcement, where they execute the law. So both domestic laws enforcement and national defense fall under the executive function. That is where they make sure that the law is executed. So anytime that, you see that the law doesn't exist in abyss. If there are laws and there is no one to execute them, then everyone can do whatever they want. But if you are sure that when you do something, the police officer can come and pick you up, or any security agency can come and pick you up, it is going to deter you, and it also provides incentive.
Please, so what is happening? Why is it that Access Network has kicked him out or what? Hello. Hey. Hello.
Yes, dear. We can hear you. I think
Maybe it's the
it's
network.
from
Okay, it's from Access ending.
Yes.
I thought it's from my end. Thank you.
okay.
Hello. So, unfortunately, I have been talking into the air for some time. Please tell me the last thing that you heard. Hello. Hello.
Hello, sir.
Yeah, like I said, unfortunately,
You are the executive function.
the executive.
Executive
What?
function.
So I've been talking all this while into the air, and no one prompted me.
Yes.
No,
Eh?
you have been saying it too.
Okay, then it means that since I wasn't online, I wasn't hearing it. This is one of the disadvantages of using online system. Sometimes, if you are busy looking elsewhere, the call will also hang up and you not even know. So I was at the executive function, right? Hello, the executive function, right?
Yes, sir. Yes, sir. Yes.
Wow, so I have to go back to all of this. All right, since I have to go back, let me just do it quickly. So the executive function, like I said, it gives the legal teeth, or it is the teeth of the law, where it provides incentive for peaceful behavior. That means that these are the agencies that enforce the law. The agencies that enforce the law. An example is the police, other security agencies, and even other agencies that help enforce the law. They all provide the executive function. They all provide the executive function. So without this executive function, the law will be as if it is not a law, because laws comes with sanction. So when you breach it, there should be something that, or there should be punishment to you. So this executive function makes sure that the law is executed in the right way. Because if you do something and you are not arrested, then there will be the incentive to do that bad thing. However, if you do something and you know you will be accepted, you'll be arrested, it is going to deter you from doing this thing. So it provides an incentive for peaceful behavior. This executive function provides an incentive for peaceful behavior. Now, both domestic law enforcement and national defense all fall under this executive function. So these enforcement and these national defense organizations and agencies all fall under this executive function. Now, in summary, let me check again. Okay, so I'm still online. So in summary, the functions of the law include: one, defending us against evil or wrong. Definitely, if you do something bad or illegal, you would be picked up. So this serves as a deterrent where people are not going to do these things. So these laws defend us from evil or good. They also promote a common good. And then they resolve disputes over limited resources. If there's a dispute, you go to court. So it is that place that we use to resolve disputes. And then it compels obedience to law and order. So if there was no law or there was no rules to govern us, then it would be like the strongest survive. It would be like the jungle. But since there are laws, there are enforcement, and there are everything, it is going to compel obedience. Even though there is these enforcement, people still go ahead and disobey the law. So just imagine, even with these, so if there were no laws, then it would be chaos. But one aspect of law is that it compels obedience. That is why we don't just get up and do whatever we want. If there were no laws, everyone could do whatever that they wanted. But because there are laws, we can't just do whatever that we want. So it compels obedience to law and order. Now, next we'll be going to the evolution of the principles of common law and judicial system. So we'll be going through the evolution of common law and the judicial system. So the common law system was developed during the Middle Ages. Before 1066, different areas of England were governed by different system of laws adopted from their various invaders who settled there. So before 1066, the whole of England had different rules based on the ones who have invaded them. Now, in 1066, when William the Conqueror gained the English throne, he established a strong central government and began to standardize the law. So his representatives were sent to check the administration in the countryside. And when they were there, they were presented with these disputes. And then they were adjudicating the disputes in accordance with the local laws. So when he became the king, after that, he was sending his people to go and then check on administrative duties. And as they were there, they would be presented with disputes, and then they would solve these disputes using the local laws. Now, when they returned back to the Westminster, they discussed the different laws which were presented around the country and decided which ones to keep and which ones to dismiss. So if they go to A and they go to B, they all listen to the rules or the laws that they were using then, and they use it to adjudicate the case. However, when they came back, they would discuss among themselves, okay, A was using this and B was using this. Now, how do we keep it harmonized? So they decided to drop some of the principles and also keep the good ones. Now, so the various rules developed became the common laws and was exported around the world to many Commonwealth countries through colonization. So when they came back, they would decide on which laws to drop and which laws to keep. So if they decide on the laws to keep, then that becomes the law that they will be applying to the whole of that jurisdiction, that is the whole of that England. So that is what they were doing. After they came back, they would discuss the laws that have been applied. They would drop the ones that they thought were not needed, and then they would uphold the ones that they thought were important. So as they were discussing and they were dropping and they were upholding, they came up with similar principles to apply to standardize the whole laws. So it became the common law because it was common in every area. So when you go to every area under England, they were using the same common laws. Now, this was spread through colonization. That's why when we started, I told you that Ghana adopted the common law system because we were colonized by the British. And you know that British colonies are mostly known as the Commonwealth countries. So Ghana is a Commonwealth country, Nigeria is a Commonwealth country. So because we were colonized, we adopted their common law principles. Now, by the 12th century, the common law court has been established to apply the common law discussed above, the common law that we discussed, and then the rates that were used to initiate the civil cases. Now, different rates were adopted for different courses of action. Litigants had to fit their circumstances to one of the available rates. If the case did not fall within any of those types of rates, then there was no way of bringing those cases to the common law courts. Now, remember I was telling you about the shortfall of common law. Now, this was one of the shortfalls. So they had rates. That is the orders that they available rates that they used to apply to their case. Now, if there is no rate available for the case that you are bringing to court, then you cannot present your case there. That is one of the disadvantages of it. So the system of rates became highly formalized and technical that the laws the court could apply based on the system were often too rigid and adequately they were too rigid to adequately achieve justice. A party who commenced the case with the wrong rate was thrown out of court. So the common law did not recognize the beneficiary's rights in the law of trust. You remember I told you about trust, where your uncle might give something, so your father might give something to your uncle for your uncle to actually give it to you when you come of age. So when that happens, we say that you are holding that thing in trust. I don't know if anyone has a baby account on behalf of your child. So the accounts, you open a trust account for your child, and then when your child in Ghana here, adulthood is basically 18 years where you are viewed as an adult, even though various provisions or various principles might adopt differently. We will look at all of those things when we get there. But basically, the Children's Act, if you are 18 years, you are of age. So when you open a kiddie account, or even those who are not that old, your parents might have opened this kind of account for you. So when you become an adult, then this account will go back to you. However, when it comes to the common law, when they were applying it, they did not recognize the beneficiary's rights in a law of trust and only recognize the trustees as the legal owner of the trust property. So also the only remedy available was damages, and they were not also adequate. So from all that I've mentioned, you can see that I am listing out the disadvantages or the should I say the shortfalls of the common law that led to the law or the court of equity. So one, if you were going to apply for a writ and then there was no writ to fit your case, then you could not send your case to court. Two, even if you begin with the rights, so even if you are able to find a writ and you go to court and then the case is going on, and then they realize that the rate that you applied for in the cases there's a mismatch. So there's a mismatch. That means that if the rate is the wrong rate that you applied through, then they would also throw your case outside of court. So one, you need to find the right rate, or you need to find a rate. If you don't find a rate, you will not be your case will not be heard in court. Also, even if you find a rate and the rate is wrong, your case will be thrown out of court. And also, they didn't recognize the beneficiary's rights in a law of trust, like the example that I've given. When your father gives something to your uncle, that when you become an adult, your uncle should give it back to you, and your uncle doesn't, even if you sue your uncle, you are not going to get it back, because the common law did not recognize the beneficiary's rights. They will just say that the legal owner is the trustee because his name is on that property. And also, the only remedy available was damages. In law, when you hear damages, it means monetary compensation. Usually, people get damage and damages wrong. So, damage is the loss that has been suffered. So, when someone causes you damage, that means that the person has made you suffered a loss or an injury. By any time that it is damages, then we are talking about the remedy. and this remedy is only monetary compensation. Monetary compensation. So the common law also only had monetary compensation. It had monetary compensation only, and also we know that it is not always that money could be able to satisfy us. Sometimes we go to court not for money, but we go to court sometimes for appeasement. Sometimes we go to court so that we'll be satisfied with the outcome. So that we even want the court to throw some people in jail just to punish them. So it is so only monetary compensation was not enough to compensate an aggrieved party, but the common law only had these things. That is why someone is unmuted. Is it Sumaila? You're muted. Do you have an issue? Sumaila, you're muted. Do you have an issue? All right. So once again, I'm using this as an opportunity. Can everyone hear me? Hello.
Yes.
All right.
Hello,
We can
sir.
hear.
We can hear you.
Yes, we can hear you.
All right. Thank you. So, like I was saying, the common law had these disadvantages. So that led to the court of equity. So, in the wake of these shortfalls, people started petitioning the court, who referred the appeals to the king's chancellor. This gave birth to a new kind of court, which is known as the court of equity, which is also known as the court of the chancery, because it was the court of the king's chancellor. So the court of equity, the court of chancery, they are all the same thing. So if in an exam, when you see the court of chancery, know that we are talking about the same thing. Court of equity and the court of chancery, they're the same thing. It is called chancery because it was manned by the king's chancellor. That is why it is called the court of chancery. Now, the court of chancery applied principles of equity based on many sources. For example, the Roman law and then the natural law, rather than the common law, to achieve a just outcome. So they went back to the naturalist law, and then they were looking at what was good and what was evil. Because if something has been given to you or given to someone and the person is not coming for it, you don't have to fight the person on it. It is not right that you get to keep the property just because the property is in your name or you are the trustee and the trustee's title is on the name. No. So the chancery also did not apply the rigid writ system. So proceedings began with bills being presented by the plaintiff in a vernacular language, not Latin. And the defendants were also summoned with the writ of subpoena to appear for personal questioning by the chancellor or his subordinates. Refusal to appear or to satisfy the decree was punished by imprisonment. So equity created additional remedies like specific performance, injunction, and also recognized the interest of the beneficiary under a trust. When we go to the remedies in contract, I will define all of these things for you. But mind you, know that these are equitable remedies. And they're equitable because the damages were not enough. Damages are monetary compensation. Damages were not enough to satisfy some aggrieved parties. So the chancery did not follow any binding rules, relying entirely on the chancellor's view of what is right and what is wrong. And for that reason, rights not recognized under common law became enforceable. So even if it is unenforceable under the common law and the chancellor deemed it as it is a wrongful principle, the chancellor will just overturn it and then he will recognize that particular right. So the court of chancery became popular, but caused resentment among the common law lawyers who argued that the quality of the decisions depended on the quality of the chancellor because precedents were not followed, and each case were considered on its merits. So at this time, the common law lawyers were also fighting back, and they were saying that there were no legal precedents because anytime they bring their case to the chancery just look at it, and then based on it, what he thinks is right is what will be given. So the common law lawyers were also pushing back, and they were saying that it wasn't right, and then they were pushing back. So conflicting judgments of the common law courts and the law of chancery were for a decision. and he advised where there was a conflict, equity shall prevail. So the king said that if there is a conflict between the common law and the court of chancery, then the equity shall prevail. So the rivalry continued for some time, but gradually reduced as equity too began to be ruled by precedents and standard principles. So the court of equity also, based on the right and wrong, as they were formulating it, they got to a time that they started standardizing it, and then they started relying on principles and precedents. So as equity took the shape of the common law with recognized principles and precedents, the Judicature Act of 1973 to 1975 was passed, and it provided that equity and common law should both be administered by all courts. So they combined the law of equity and then the common law, that now all courts can practice the both. So the Judicature Act did not fuse the common law and then the equity, but only their administration. Go there and then you can rule with common law or the law of equity, but it didn't fuse the two together. So there is still a body of rules of equity which is distinct from the common law. However, the same court can administer both. Equity created maxims which had to be satisfied before equitable rules could be applied. So we had maxims, I think it was 10, but now it has been expanded. And then even when you Google, you can get about 20 maxims of equity. So an example can be equity follows the law, but not slavishly. So equity will follow the law, but if the law is unfair, then it's not going to follow it throughout. So that means that the court will first apply common law, but where the application of common law will lead to injustice, then equity must prevail. So equity follows the law, but it does not follow the law slavishly. So when they combine it, and they said that the courts can now hear cases of both nature, then they will start with common law. But if the common law was given an unjust or an unjust outcome, then they would refer back to the court of equity or the laws of equity. So the maximum of equity, we have a lot of them. We have, he who comes to equity must come with clean hands. That means that if you are going to court that someone has done something bad to you, you must make sure that you yourself, you are not tainted with anything bad. So he who comes to equity must come with clean hands. If you are accusing someone of something, make sure that you are of the similar crime or any other crime. So he who comes to equity must do equity. These are just examples that I'm giving. You can go and Google and then check the rest later. He who comes to equity must do equity. That means that if you are coming to take something from someone in court, make sure that you've done your part of the contract. So for example, there's a contract, you must do something for someone and someone must also do something for you. The person has not done his part and you want to sue the person. Make sure that you yourself also, you've done what you are supposed to do before you can sue the person. So he who comes to equity must do equity. And another maxim is delay defeats equity. Delay defeats equity. So sometimes, even if you are right and you don't seek for the remedy earlier, you might not be given the remedy. Even though in normal circumstances you are entitled to that remedy, you will not be given that remedy. That is why we have the statute of limitation as to when something can expire. So when someone wrongs you, you have a limitation. Usually in contracts, with a simple contract is 6 years and then specialty is 12. So if someone wrongs you, someone doesn't do something in a contract, make sure that you sue the person with these years, or else when you go to court, you would not be given a remedy. Now we move to judicial precedents. Judicial precedents. Today we'll close at 7 o'clock. The time is 6:50. So if you have any questions, you can ask. If you have any questions, for example, there are some parts that the network wasn't good, maybe you don't hear me well. Let's ask and then let's try and then.
Please, sir, can you kindly adjust
So
yourself?
any questions? Can I?
Please, sir, can you kindly adjust yourself? The break is kindly adjust yourself. The screen break
Okay,
is
so we are having.
bad.
All right. Wow. Something else, because I keep switching from Telecel to MTN, but none is better. As for Tigo, there is no network here, so I can't even switch to Tigo. As for Tigo, there's no network here. All right, so I'm hoping it is okay. All right, so maybe there was something you didn't hear well. There's a question you want to ask. You can ask before we close. Anyone? Okay, so since you are not asking me questions, let me ask you questions. Since you are not asking me questions, let me ask you questions. Justice. All right, so if there are no questions, then let me just make this announcement that now on Sundays, the class would be from 4 o'clock to 7 o'clock. 4 o'clock to 7 o'clock, 3 hours. I know that you have a class at 2:30, but that means that class is not going to come off. It's going to be 3 straight hours, 4 o'clock to 7 o'clock. All right, so any questions, contribution, even if it is not in relation to this, what you treated today, anything that you want to add, you can add before you close the class.
Hello.
All right, and if you are here and someone is talking, who is talking? I can't hear. Is the person saying no?
Yeah, I'm the one talking. So please, the online lectures, like the lectures attendance, are you judging the attendance or those are the me? I'm from the Tamale Center. I don't know whether we maybe meet at Tamale or you, unless we are judging the attendance online.
All right. So I don't know about other courses, but for business law, I am taking Tamale Business, Wenchi, Enchi, and Fiatman, and it is strictly online. So you may have some classes via what's the name, face to face. But when it comes to business law, I'm taking Tamale, Wenchi, Enchi, and Fiatman, and it is strictly online. And the time, even though you have your respective time on your timetable, we've agreed that we are going to meet from 4 o'clock to 7 o'clock on Sundays for our 3-hour lecture. So if you have any colleague from Tamale and the person is not aware, kindly prompt that person for me. That the class will be from 4 o'clock to 7 o'clock. All right. So also, if you are not in Tamale,